Hi, good afternoon, everyone. Welcome. I'm John Landesman. Welcome to our webinar today, The Impact of the 2020 Election on Labor and Employment Law. Let's go over some webinar logistics before we jump into the presentation. Everyone who is on the webinar with us today is muted, but we do want and we ask that you submit questions. And so there is a question box where you can submit your questions in writing. Please feel free to do so throughout the presentation. We'll be looking and checking in that box and trying to answer the questions as we go along. And in addition, we'll have some time at the end of our presentation where we can take some additional questions. I want to advise everyone that this presentation is being recorded and it will be distributed after the webinar. So for that reason, to the extent that you're asking questions, you probably wouldn't want to mention your company name or a specific situation that would identify your company. For those of you who don't know me, and I know that we have a lot of people on the phone that are already clients of the firm, my name is John Landesman. I'm a partner at Cohen, Seglias, Pallas, Greenall, and Furman. I've been practicing at Cohen Seglias and devoting my practice to labor and employment issues, representing employers and management since 1998. That's pretty much the focus of my practice. You see a picture of me there on the left. That's I'll brag for a moment. That's pre-pandemic, or at least my pre-pandemic diet. That's probably about 60 pounds or so ago. On my right, that young man is Marc Cytryn, who's a very fine labor and employment lawyer who's a member of my team, and he practices labor and employment law also as well, exclusively. And Marc and his wife just welcomed their first new daughter just a couple of months ago. So congratulations to Marc. With that, we have a lot of information to cover. So let's get started. We have obviously a very big election that took place last month. And so there were many, many differences between the two presidential candidates, but it's not just the executive branch where we're looking for changes. There's going to be broad change that we anticipate really from the federal and state levels, from all three branches of government. And so with respect to the executive branch, we know, of course, that President-elect Biden will have the power to issue executive orders where he, with a stroke of a pen, can change the law. And in many areas, and we'll talk about some of them, we anticipate that he's going to exercise that power. In addition, during the campaign, we heard from President-elect Biden that we can expect some changes, some very significant changes with the administrative agencies like the Department of Labor, the EEOC, the National Labor Relations Board, all of the agencies that have a real impact on workplace issues. We can expect changes. For example, at the EEOC, there's been a promise that the budget for the EEOC, which is the agency that investigates discrimination claims, the budget is going to be doubled. So we're going to see a lot more investigations and a lot more thorough investigations, presumably, by the EEOC, which is not good news for employers and the business community. We're going to see at the National Labor Relations Board, which is the federal agency that deals with union issues and labor issues, we're going to see the tide change, and a majority of the National Labor Relations Board, there's 5 members, a majority will presumably be Democrat appointees. That won't happen until a current appointment expires in August of 2021, but we all have that on the calendar as labor and employment lawyers when there'll be a major shift. And then there'll be key appointments within agencies like the Department of Labor, OSHA, et cetera. On the legislative front, there is significant uncertainty still. We know that the Democrats took the House, but when we look at the Senate, things are still wide open, and I won't spend a lot of time on it, but as most of you have probably been following in the news, there's going to be a rerun election on January 5th in the state of Georgia, where both seats are still up for grabs. If the Democrats take those 2 seats, then we have the stage for a deadlock, basically a 50-50 split in the Senate. That's probably unlikely, but if it happened and it's a 50-50 split, then Vice President-elect Harris, as the vice president, would have the controlling vote whenever there's a split in the Senate on all issues, not just labor and employment issues. So because of that uncertainty and because we don't know whether or not we're going to have a Republican or Democratic-controlled Senate, that will have an impact on whether or not we see a lot of legislation that goes through Congress and makes its way to the president's desk, or we may wind up seeing, if the Republicans control the Senate, then presumably we're going to see more executive orders than we would otherwise expect to see. With respect to the judiciary, right now we have a conservative and what most consider pro-employer Supreme Court, and the Supreme Court decides a lot of issues that filter down to all the other federal courts and shape labor and employment law on a national basis. We presently have 6 Republican justices out of the 9. And as I'm sure many of you heard during the campaign, the issue that's on the table is whether or not the president will attempt to, quote unquote, engage in court packing, increasing the number of justices from 9 to some other number so that there can be additional appointees on the court that would ultimately constitute a Democratic majority. What has President Biden said? The latest that we've seen is that upon him being sworn in, he intends within the first 6 months to appoint a bipartisan commission to examine that issue and make a recommendation to him. So presumably sometime in 2021, we'll have a greater view of and knowledge about what the court packing is going to be. So when we look now, and for the rest of the seminar, we're going to jump through a bunch of specific issues with proposed legislation or things that we think are likely. I'll cover a bunch of them. Marc Cytryn is going to cover some of them as well. The first one, and the biggest one that maybe you've heard about, it's been all over the news, it's called the PRO Act, the Protecting the Right to Organize Act. And a version of this law actually made its way through the House in February of 2020. Of course, it died in the Senate, but we expect that it's going to be resurrected. It was part of the Biden platform, and it has sweeping changes to a number of areas. And so we expect that some form of the PRO Act is either going to be implemented legislatively through Congress, or we'll see part of this in an executive order that'll be signed by President Biden very soon, as in within the next few months. This is not, this is not sort of pie in the sky. This is really happening. So we expect that the PRO Act, as its name implies, is going to have a real impact and increase in union organizing activity in a variety, in almost every sector in the economy, including construction, but including a lot of other industries as well. What are some of the specific provisions of the PRO Act that are on the table? We expect to see the return of the so-called ambush election rules. What's an ambush election? Well, if a union wants to organize a company, they go to the National Labor Relations Board, they file a petition, and they say, here, National Labor Relations Board, here's a petition, we want you to schedule an election. And let's say the election is scheduled 40 or 45 days out. That gives the employer a period of time to get its message out to the employees, to do some campaigning and to tell the people what their views are on unionization if they want to oppose it. Well, an ambush election and what this PRO Act would do is shorten that period of time dramatically, so that the date of the petition, maybe you see an election within a very short period of time, a couple of weeks thereafter, there's no time for the employer to respond. Another thing that the PRO Act could do, and this is maybe even a more dramatic impact on union organizing, is taking away the right to a secret ballot election. Right now, in order to have an election for a union, the people who are voting, the bargaining unit employees, go into a little voting booth. It's a little mobile booth that the board agent sets up, and they get a ballot and they check the box. Yes, I want the union, or no, I don't. And then they cast their vote in secret in a little voting booth. And then the board agent counts the election, counts the votes that are cast. What the PRO Act would do is say, you know what, in some cases, we're not going to do a secret ballot election. Instead, we're going to just count authorization cards. So a union business agent can go around at night to the employees' homes, knock on the door, and say, here's an authorization card. I want you to sign it, showing your support for the union. And if they can collect 50% or more of those cards, then we don't even need an election. We'll just count the cards and we'll say that the union is recognized. Now, that's a very dangerous thing for employers. Are we really seeing the employees' true intent that they want to vote yes or no, like in a secret ballot? Or are they being intimidated? Do they feel funny? Are they just signing it so they get this person out of their home or away from their home as quickly as possible because they feel uncomfortable or they don't want to have a confrontation? Again, secret ballot elections, we think, are important. The PRO Act threatens them. There are going to be limits on campaigning during a union election as far as when and what an employer can say. There's the possibility of interest arbitration. What's interest arbitration? Well, if an employer has an election and the union wins, does that mean that you have a collective bargaining agreement? The answer is no. The employer and the union need to sit down and negotiate. That's all that means. So if I lose an election, all that it requires is for the employer to bargain in good faith, to sit down at reasonable times, reasonable places, and talk about wages and other terms and conditions of employment. You don't have to agree to anything. And if there's no agreement, what happens under the current labor law? If there's no agreement, then the union can call a strike. That's their weapon. They can try to pull the people out on strike. But what the PRO Act would do is it would say, well, if you don't reach an agreement within 2 years, we're going to appoint a neutral, an arbitrator, who's going to listen to both sides, and then the arbitrator will decide what the terms of the collective bargaining agreement will be, and will impose that on the parties. So it's the existence of an agreement without the parties reaching an agreement is what we're talking about under the PRO Act. We're also looking at resurrecting the persuader rule. What's the persuader rule? The persuader rule is, it bounced around in federal court. It was struck down ultimately. It's a rule that requires persuaders or consultants in labor relations matters to issue all sorts of disclosures and file forms with the federal government talking about their activities. So the persuader rule in this context would mean that if I, as an attorney, even though all of my communications are attorney-client privileged, talk to one of my clients about union organizing and give them certain advice, that then I have to file a form with the federal government telling them all about that advice and telling them how much I got paid to do it. Again, a very anti-business sort of a rule. What else is in the PRO Act? The PRO Act also makes changes to the federal labor law. It would do away with or severely change the secondary boycott rules. What's a secondary boycott? Well, when a union is unhappy, let's say because there's an open shop or non-union contractor who's performing on a site, and the union wants to go out and have picket signs or have the inflatable rats, there's rules that govern the time and the places where they can do that. Many of you who are in construction are probably familiar with dual gates or reserved gates, which allows you to get union people on a site and non-union people on a site. Well, the PRO Act could do away with that and could say, you know what, we're not going to have reserved gates anymore. We're going to allow the union people to picket all the gates. Again, we don't know what the final law is going to say, but this could be very significant, especially for people in construction. The PRO Act also could reinstate the purple communications case. What's purple communications? That's a case that basically says that an employee can log on to their employer's email use employer email, then send and blast emails company-wide and talk up the union without getting disciplined. The PRO Act talks about replacement workers, so all the workers go on strike and I need to hire replacements. The PRO Act would make it more difficult, if not impossible, to hire those replacements, provide additional protections for striking workers. Right now, striking workers have different protections. If there's an economic strike or an unfair labor practice strike, a lot of those distinctions presumably could go away. The PRO Act would also do this, and this is significant for union and non-union companies. Right now, if someone wants to say that you violated the labor law, one of your employees or a union, what do? They go to a federal agency. It's called the National Labor Relations Board, and the agency assigns an investigator. And if you lose, what do? You have to post a notice in your workplace. Maybe you have to pay back pay, the amount of pay that you would have had to pay the person otherwise if they were fired. Now the PRO Act would change all of that. The PRO Act would say that violations of federal law all of a sudden are going to become a federal case. And so they could file them in federal court and make a literal federal case out of every single unfair labor practice charge. The PRO Act would also increase the damages, providing 2 times back pay, fines up to $100,000 per violation. And President-elect Biden has actually said that he would contemplate and consider for some violations imposing criminal sanctions for violations of federal labor law. Again, a totally new level of liability for employers when it comes to labor law issues. The PRO Act isn't limited to union and labor issues. And this may come in the form of legislation in the PRO Act. It could come by executive order. We're expecting to see more laws at the federal level addressing worker classification as employees versus independent contractors. And particularly, we're seeing a lot of class action cases being reported with so-called gig workers. So what's a gig worker? An Uber driver, a Lyft driver, somebody who's delivering food or essentially working as a taxi driver. Are those people employees? Are they independent contractors? But it's not just in that context with gig workers. This is a very big issue also for all other industries, particularly in construction, is another focus. And so the PRO Act, and again, President-elect Biden may do this without the PRO Act. He may do it by implementing or signing an executive order, is going to adopt what's called the ABC test. The ABC test is already the law in numerous states, including in California. The ABC test is a very tough test for employers. It creates a presumption that all of the workers that are doing work for your company are employees, and they shouldn't be 1099 people. They shouldn't be 1099. It puts the burden of proof on the employer, and it's not by a preponderance of the evidence. The employer has to show that these people or these workers are actually independent contractors, and we need clear and convincing evidence, a much higher standard than a preponderance of the evidence. So again, very significant in terms of worker misclassification. When we're talking about worker misclassification, this is just sort of a background. We're looking at wage and hour or overtime liability, income tax withholding liability, unemployment comp insurance, and that might be one of the most common ways where I see this classification issue being raised via audit by the Department of Labor is in the context of an unemployment comp audit. It can also come up with workers' comp audit. So these misclassification rules, they lead to tremendous liability in those areas. And for Pennsylvania employers in construction, we also have to worry about Act 72. Act 72 in Pennsylvania is only for construction employers. It was implemented in 2011. So this is just sort of a review of what the law is. It requires that if I'm going to pay someone with a 1099, I've got to meet multiple factors. I've got to have a written contract. The person has to be free from direction and control. the person has to have their own independent business that's separate from the employer's business. Act 72 is really a very, very difficult law for a lot of construction contractors to meet if they're using independent contractors or designating people as independent contractors. I see it in the painting trades. I see it with carpenters or laborers who are hanging drywall, roofing contractors. I mean, those are the areas where I think I've seen it most over the last 5 or 7 years or so, but I expect to see a lot more of it. With that, Marc Cytryn, why don't you tell us a bit about the new joint employer rules that we can expect to see?
Thanks, John, and good afternoon, everyone. So John touched upon the joint employer issue a bit with the PRO Act, but this is an issue that's been around for a long time, and it may be familiar to some of you with respect to the Fair Labor Standards Act and also the Family and Medical Leave Act, both federal laws. And under those laws, the government, the Department of Labor, will look at this joint employer test to determine whether or not, in some instances, more than one company has treated their workforce as the employees of both of those entities. And the test that's used to determine joint employer status underwent a significant change in August of 2015 when the National Labor Relations Board decided the case in Browning-Ferris. And that case was significant. And since that being issued, it was also applied by district courts across the nation to say that it's no longer necessary for a company to exert direct and immediate control over an employee in order to be deemed a joint employer, but rather it is possible for a company to be deemed a joint employer by exercising reserved or indirect control. And that's an important distinction because it led to situations such as where you have a temporary staffing agency that's providing employees to a contractor. And if both entities exert some control, at least, over the employees, then both could be deemed joint employers. So essentially, it was a tough decision for employers to swallow because it made it more easy for employers, two companies, to be deemed joint employers. Now, more recently, in 2020, the U.S. Department of Labor issued a final rule. And that final rule under the Trump administration essentially reverted back to the old standard that was in place before Browning-Ferris to say that two different companies do need to both exercise direct and immediate control over their employees in order for them to be deemed joint employers. So under the Trump administration, you had, as I said, a reversal of Browning-Ferris, and employers took a breath with that because for a moment it made it more difficult for the Department of Labor to argue that two different entities were joint employers and therefore liable for the same things for their employees. And, you know, more recently, there's been a case, really a rogue decision issued by a New York District Court judge striking down the Department of Labor's final rule. But that case is now subject to appeal, and the appeal is currently pending. And the outcome of that appeal will have certainly an impact on the joint employer test going forward. But it's also important to note that the Biden administration is certainly in favor of the Browning-Ferris approach that was in place before the Trump administration's final rule. And it's possible that the Biden administration could try to seek to revert back to that more easy test for joint employer status that was in place before Browning-Ferris, and they could do so through legislation, including through the PRO Act that John went through earlier. So it's important to keep in mind that this joint employer test is continuing to change and will likely do so under the Biden administration through legislation.
You know, before Marc continues with the with some very important COVID-19 issues, I've got a couple of comments here about we can't see Marc. Unfortunately, we had a technical issue, so while Marc is joining us, we can only get him by audio, not by video. I'm sorry to interrupt you, Marc. Please go ahead.
No, thanks, John, and I apologize for that as well. And so going on to COVID-19, which I can guess is probably one of the favorite topics among everybody, on the call for at least the last 9 to 10 months, and it's really a very important one as we head into the new year and the new administration as well. And under the Trump administration, for the most part, the guidance, the regulations, the workforce policies and protocols have been left to state and local governments to issue guidance and regulations as they deem fit. The federal government, on the other hand, has taken a pretty hands-off approach, and there has not been much in terms of federal guidance as to what employers need to do to address the COVID-19 situation. We can expect under the Biden administration, based upon his messaging during the campaign and since then, that the Biden administration is likely to take a more hands-on approach, and they can do so in a variety of ways, including by having OSHA issue more stringent guidance or regulations, and also to take a harder line approach on what penalties will be imposed with respect to employers that fail to comply with OSHA's general duty clause, which, as you know, requires employers to provide a safe working environment for their employees. So one hot button issue is masks in the workplace. And a lot of state governments, of course, have already mandated that masks must be worn in the workplace. They've also mandated social distancing and other policies and procedures that employers must take. But there has not been anything yet from the federal government in that regard, except for CDC guidance. So it's very possible, based upon President-elect Biden's messaging, that a national mask mandate could be put into effect. And that could have an impact on employers and how they're required to enforce those policies under OSHA. Now, OSHA does have the authority under that general duties clause to take a look at what employers are doing. For instance, if someone complains that an employer is not following mask mandates, et cetera, in the workplace or CDC guidance, it's possible that OSHA could take notice of that and want to conduct an inspection. So it's important to pay attention to those regulations that can likely be issued by OSHA and the Biden administration going forward, and make sure that you're up to date in compliance. With respect to guidance on employee vaccine requirements, that's also a really important issue as we head into the new year. And of course, as the vaccines are really just coming out and getting the ball rolling with respect to people getting vaccinated. So the EEOC has already given guidance to say that employers, because of the pandemic, have wide discretion to conduct employee health screenings and other protocols to be put into place in order to ensure that the spread of COVID-19 is mitigated. For instance, employers now, pursuant to EEOC guidance, can conduct pre-shift temperature screenings of their employees. So people that are coming onto the work site before they're allowed to begin their shift, they can be screened, have their temperature taken, in other words, by the employer to make sure that they don't have symptoms associated with COVID-19, including a fever. So under that guidance and the EEOC's approach so far, that has given employers wide latitude in what they're able to do under this situation, it's likely that vaccines will be able to be mandated by employers, except for the fact that employers will still need to provide exceptions for instances where an employee has, let's say, a disability or a religious belief that precludes them from being vaccinated. So in other words, while employers may be able to introduce programs that say everybody should get vaccinated, they still will need to make exceptions under the Americans with Disabilities Act and Title VII when appropriate. And that comports with the prior guidance and situations in which employers require employees to do other things. In other words, they need to be evaluated on a case-by-case basis. And that's an important thing to keep notice of going forward. And there should be guidance. We hope that there's more guidance issued on that exact topic moving forward, so there is a more clear and definitive picture. And another hot button topic that everybody's been obviously talking about for the last 9 to 10 months is the Families First Coronavirus Response Act. That law went into effect back in April. And of course, employers with 500 or fewer employees are required to comply with it. And essentially what that law requires is that employers provide up to 2 weeks of paid sick time, and then an additional 10 weeks, up to 10 weeks of extended paid family leave for certain situations related to COVID. The 10 weeks of paid expanded family leave relate to child care issues that arise under COVID. And that leave has been required since April, as I mentioned, The law is currently set to expire on December 31st of 2020, and under the Biden administration, however, we expect that he will likely want to expand and also extend that law to go into the new year once he takes office. I should note, however, the current stimulus bill that's on the table before Congress and being negotiated does not include any provisions related to the extension or expansion of the Families First Coronavirus Response Act. At the same time, again, though, the Biden administration, once they get into office, will likely try to reinvigorate that law, according to President-elect Biden's messaging again during his campaign and since then. An important point to keep in mind with respect to the expiration date of the FFCRA is that if an employee needs to take paid sick time or expanded paid medical leave, and they make that request, let's say on December 27th, they would not be able to continue taking leave after the 31st, even if their leave began before that date. And that's a key point to keep in mind. So December 31st, as of right now, is the cutoff date for the FFCRA, and employees either who have began leave before then or want to take leave after are not entitled to it. And the last point I'll make is with respect to any leave that is paid out or has been paid out before the end of the year, of course, you should seek to apply for payroll tax credits when you file your quarterly returns to get reimbursed for the wage costs and the medical cost expense that you dished out for employees who took leave. And with that, I'll hand off the next slide to John.
Yeah, and I'll just comment on the FFCRA. To me, it's really striking. Well, it's striking that Congress hasn't been able to pass the second round of stimulus legislation. But even just a bill to address the extension of the FFCRA, given where the numbers are with respect to the number of COVID cases, to have the FFCRA expire now at the end of the year, it would seem to be so counterintuitive, but it looks like that's actually what's going to happen. That doesn't mean that the people shouldn't get any time off for all your employers out there, but it means that to the extent that they're going to take time off and the FFCRA is not there, you won't be able to receive a payroll tax credit. In other words, Uncle Sam isn't going to pay for that time off anymore. It becomes the burden on the company, on all of the businesses out there. So let's talk about another aspect, completely walking away from COVID-19, but a very hot issue is non-compete agreements. Having practiced law in this area now for over 20 years, I can tell you that there has been a proliferation of the use of non-compete agreements among employers in all industries, and that proliferation is not just limited to highly compensated employees. It used to be that only people at the very top of an organization, or maybe your key salespeople, your key estimators, that you'd tie them up with restrictive covenants. Now we're seeing restrictive covenants being executed by blue-collar workers. In fact, Marc, Cytryn, and I right now are in the middle of litigating a very contested case in federal court in Louisville, Kentucky, for one of our clients. And the allegation involves the enforcement of non-compete agreements against employees who are working as flaggers for a traffic control company. So these are the people who are in the street waving traffic, waving flags and signs and directing traffic around linemen and utility workers. These people who are the flaggers who had to sign these non-compete agreements, they were earning between $11 an hour and maybe $16 an hour. And here we are in federal court asking a judge and ultimately a jury whether or not they should be held to non-compete agreements. There was a case not long ago that was reported in the New York Times that involved the sandwich chain Jimmy John's, and they have the guy or the lady who's behind the counter sign non-compete agreements, even though their job basically entails operating the cash register and making sandwiches. That person has to sign a non-compete agreement. It shows you how widespread the proliferation has been. And so the backlash is from people on the left side of the aisle, and that includes President-elect Biden, who's supporting the ban, the outright ban of non-compete agreements on a federal level across the board, with some narrow exceptions that they're talking about, where they'll let them be in place only if it's absolutely necessary to protect a company's confidential and proprietary information or trade secrets. Now, no one knows exactly where this is going to land. There's already been in Congress 3 bills that have been introduced, which would prohibit non-compete agreements for low-wage workers. Those bills didn't make it out of either House of Congress. They didn't get very far. There is legislation on a state level to that effect in some jurisdictions, and there's a growing trend there. And as I mentioned earlier, if the Democrats take both houses, if they take the Senate, we may see legislation, but more likely we could see an executive order, or we could see rulemaking from an FTC board of commissioners that's appointed, or at least a majority of whom are appointed by President-elect Biden. So if there's a majority of the FTC commissioners, what we've heard is that in the very near future, the FTC could propose rulemaking. The FTC, the Trade Commission, they can say that it restricts trade and it's unfair if you don't let low-wage workers freely move from one company to the other and have job mobility. So they could propose a rule. Forget about what Congress does. We'll have an administrative agency issue a rule that bans non-compete agreements. That's likely going to be only for low-wage workers. Where do we draw the line? Is it people who earn $8 an hour, 10, 15 an hour? We don't know yet, but they've already, as you can see the center bullet point here, they've already had a public workshop to consider the issue. It's on everyone's radar. It's coming in all likelihood in 2021, some sort of a ban or restriction on an employer's right to use non-compete agreement clauses. What else are we looking at in terms of what's on the horizon in 2021? Well, there's a piece of pending legislation, and again, the Biden administration has explicitly said that they are in favor of it. It's called the Forced Arbitration Injustice Repeal Act. So what is this all about in plain English? Well, if I'm an employer, what's my worst nightmare? One of my worst nightmares for any company, that I'm going to get sued by one of my employees. They're going to drag me into court in front of a jury, and they're going to say that I discriminated against that employee because of their race, their religion, their national origin, their sex, their age, you name it. And then the jury is going to get really, really upset and angry with me and make me pay that employee millions of dollars by issuing a judgment or a verdict against me. So what do employers do when they want to avoid that exposure to liability? They have their employees sign an arbitration agreement that says, I promise I won't sue my employer in court, and if I have any claims against the employer, I understand that I'll be required to go in a confidential setting, so it won't be a public document. I'll go in a confidential setting and I'll arbitrate those claims, and I'll be legally bound by whatever the arbitrator says. And what's the chances that the arbitrator, who's usually a retired judge, is going to lose his head or her head and say the employer has to pay millions of dollars? The chances of that happening versus a runaway jury, it's a very different risk. So what does this Forced Arbitration Justice Repeal Act do? It says that employers, you can't do that. You can't take away the right of the employees to go ahead and to litigate their cases in court and force them to arbitrate. So this is taking away a business's right to impose arbitration on the employees. Again, it can be very significant, especially for those businesses who are on the line, who are using those sorts of arbitration agreements with your employees. We're also looking at, and this is sort of self-explanatory, federal minimum wage right now, $7.25 an hour. Biden supports an increase to $15 an hour. This is something that he will not be able to do by executive order. It's going to require congressional action, and this is obviously a deeply partisan issue. So we'll have to see where it comes out, if there's some sort of compromise. I don't know if that's on the table in this next legislative session immediately, but it is certainly on the horizon, and there's a growing movement to address the minimum wage and increase it at a federal level. Marc, why don't you tell us about paid family and medical leave? And this is separate and different from what we were talking about a minute ago with the FFCRA.
Thanks, John, and that's right. So many of you are familiar with the Federal Family and Medical Leave Act, which applies to employers with 50 or more employees, and that's been in effect for a long time, but it provides for unpaid leave, up to 12 weeks of unpaid leave, and also, of course, that leave can be taken on an intermittent basis. But here, President-elect Biden has expressed his support previously and continues to for 12 weeks of paid leave for maternity, paternity, and serious health condition issues. So essentially what his position is the Family and Medical Leave Act that provides for unpaid leave to so many employees could also provide paid leave instead. And that would be a significant change. Frankly, it's unclear whether or not that law or that proposed legislation could pass the Senate, but it is certainly on President-elect Biden's agenda. In addition to that, he also favors the Pregnant Workers Fairness Act, which would expand the accommodations that employers are required to provide to employees for pregnancy-related reasons, such as if they need to be out of the office due to appointments, et cetera, much of which are already protected under the Americans with Disabilities Act and the Pregnancy Discrimination Act. But there is an expansion here that President-elect Biden is seeking to pursue. And I should also note that with respect to paid leave, many states in our area, including New Jersey, for instance, already provide paid family leave. For instance, if somebody needs to go out on leave because they have a child that's being born or they have a family member with serious health condition, et cetera, they can apply for family leave benefits through the state of New Jersey. And so they do have access to paid benefits now. However, President-elect Biden's plan for paid leave would be a federal law, and so it would apply nationwide as opposed to just the states that are currently mandating it. So it's important that we pay attention to that and see how it develops as well. With respect to unemployment compensation benefits, during the COVID-19 pandemic, we've already seen a big expansion of unemployment compensation benefits. For instance, many employees who would otherwise not have been eligible for benefits if they were no longer able to work, for instance, because they're out of work due to needing to care for a child or a family member as a result of COVID. Previously, they wouldn't be eligible for benefits. However, under the CARES Act expanded provisions, they have been. And so COVID-19 has already shown us a big increase in the number of individuals and the reasons for people being eligible to collect benefits. President-elect Biden's platform also promotes the idea of increased eligibility and increased benefits from a federal perspective. One way he's looking to expand those benefits is through a work sharing system. And if that were to pass, what that means is employees who could work reduced hours or need to work reduced hours could have their wages essentially supplemented by federal level benefits. And I should note, states are already having these work share programs, and they've had them in effect, but not on a federal level. For instance, Pennsylvania has a version of a work sharing unemployment compensation benefit program, but it's by no means do all states have them. And of course, federal legislation in that regard would change the landscape. With respect to increased eligibility and benefits, one thing that the Biden administration, the incoming Biden administration, is looking at is increasing the number of people that will be eligible by saying that if somebody's hours are reduced to just 80% of the normal number of hours that they work, they would be eligible for partial unemployment compensation benefits. Now, before the current state of affairs is that for the most part, states say you have to have had your hours reduced to at least 60% or sometimes down to 40% of what they normally are in order to be eligible for partial benefits. Obviously, if that number increases to 80%, that would make many more people eligible who are working just slightly reduced hours. So that's another thing that the Biden administration would likely take a look at. And if for some reason these measures are not passed by Congress, which is certainly a question given the makeup of the Senate right now, it's possible that President-elect Biden, once he's in office, could also facilitate these changes to go into effect by encouraging states, for instance, by providing tax credits to states that participate in these types of programs, and he could likely do so. So another key component of President-elect Biden's platform is that he wants to expand the equal pay protections that apply to employees across the country. Of course, the Equal Pay Act has been in effect for some time, and also under Title VII, of course, employers can't discriminate against employees based upon a pay differential due to sex or sex. But the equal pay procedures and policies that the Biden administration are looking at would also possibly put into effect the pre-Obama era rule that employers are required to publicly disclose the pay data that's contained on their EEO-1 reports. And that's significant because if there is an instance that arises where an employee complains about a pay disparity or perhaps files a lawsuit, a wage and hour case against an employer, and those EEO-1 reports become discoverable, in other words, they're produced in the litigation, and they do show disparities, it essentially could serve as a roadmap to a plaintiff's attorney or an employee to bring their case. And so that is a big issue. And it hasn't been finalized yet, but the Biden administration could make that change either through executive order or rulemaking. Another item to keep in mind with respect to rulemaking is that the Biden administration is likely going to direct the Office of Federal Contract Compliance Programs to more strictly enforce prohibitions against pay disparities with respect to federal contractors. President-elect Biden has expressed that that's something that's important to his agenda. With respect to actual legislation, while nothing's been put into place yet, President-elect Biden also supports the Equality Act, which has passed the House, has not yet passed the Senate, but it would revise the Equal Pay Act to also cover sexual orientation and gender identity, in addition to, as I just mentioned, the fact that it already covers sex. So that would expand that law.
I'm sorry to interrupt, but just to understand the significance of that. So all of these equal pay issues that Mark just went through, 3 of them, they're directed at the gender wage gap, the difference that men and women get paid for performing the same work. And there are different studies and different numbers out there, but most people would say, well, women are getting paid 80 cents for every dollar that a man gets paid for performing exactly the same work. So what these laws are focused on is eliminating that gap with respect to the 2 genders. Now the Equality Act takes it one step further and throws in sexual orientation and gender identity and wants to look at the gaps that exist with respect to those classifications. Sorry, Mark, go ahead.
No, thanks, John. I think that's a very good point. And moving on to the salary bands, which also are in conjunction with the equal pay issues. So states, for instance, have already enacted some salary bands. And for example, the state of New Jersey has already enacted legislation that says you can't inquire into a person's salary history during the interview process. And in fact, when that happens, it often leads to potential claims for disparate impact. And what that means is a job candidate or an employee can argue that my salary that I was making was really attributed to me because of my sex or gender. And so the employer gave me a lower salary and it's because of my sex or gender based upon my history. And so that's the legislative purpose behind these types of bans. Once again, states have enacted these bans, but they have not been enacted yet on a federal level. It's likely that President-elect Biden's administration will pursue that option, though, and it would need to take place through legislation in all likelihood.
Okay, and we've got about 10 minutes left, so I'm going to encourage everyone, if you have questions, to ask them, and I see that we have a couple of them. So before we jump right into the legalization of marijuana, let me address a couple of the questions. I'll throw them out. We have one of our participants who says, is an employer required to pay benefits into a multi-employer benefits plan for employees who are out on FFCRA, family leave, or sick leave? And the answer is, remember, we have a $511 cap per day that the employer has in terms of wages and healthcare. You can't apply contributions to, let's say, pension, annuity, or industry advancement fund, or some other fund. We're not going to be able to take a payroll tax credit for those contributions. Does that mean that if you are a union company, you don't have to make the contributions? Well, unfortunately, I can't give everyone the same answer to that question because it depends upon the particular collective bargaining agreement. Some collective bargaining agreements will say that the employer has to make a contribution for every hour paid, regardless of whether or not it's worked. Other collective bargaining agreements say the employer is only obligated to make contributions to the funds for hours that are worked and paid. So it's a matter of looking at your collective bargaining agreements to figure out what your obligations are. And then, of course, if you're unlucky enough to have an agreement that's silent on the issue, well, then you're talking about probably getting a hold of the multi-employer association to which you belong and seeing what their interpretation is. Another question, let me just see here. Actually, let's continue on because we do only have a few minutes, and I know that a lot of you are interested in marijuana in the workplace. So, Marc, why don't you tell us about that in our remaining time?
Thanks, John. No problem. So marijuana legalization has been a big issue, and many states have enacted laws in that regard over the past several years. But of course, federal legislation has not yet come, and that is something we could likely see under the Biden administration. In particular, the Marijuana Opportunity, Reinvestment, and Expungement, or MORE Act, is sponsored by Vice President-elect Kamala Harris. It's already passed the House and will go to the Senate for review. It's unclear whether or not it will pass the Senate, but if it does, what this law would do is effectively remove marijuana from the list of federally controlled substances, and it would no longer be illegal under federal law. Of course, that would have a huge impact on employers across the country with respect to their drug screenings and how they approach the issue of marijuana in general. In terms of the states that have already legalized marijuana or done so for medical purposes or limited purposes, and with respect to full legalization, there's already 15 states that have done so. Medical use and decriminalization, you can see, has taken place in 12, and 17 states have only decriminalized marijuana without making freer restrictions on how it can be used. Many states have also limited it to medical use. But these numbers are likely to increase as the years go by, as many states eye continuing to legalize marijuana, not only for medical use, but also for recreational use. So the first states that have addressed the issue of medical marijuana have, for the most part, said that an employer cannot discriminate against somebody just because he or she is a licensed medical marijuana user. Now, that doesn't mean in those states that somebody can just show up to work and be selling or using marijuana at the workplace, but to the extent that somebody is a licensed medical marijuana user and shows the employer his or her license or prescription card, they can't be discriminated against just for that. At the same time, it's also important to note that 14 states currently have exceptions also for if there's a safety-sensitive job. In other words, and this applies largely to the construction industry, if there's a job that involves very safety-sensitive functions, there is an exception to employees being able to be under the influence, especially of marijuana, or even being assigned to that job if they are a medical marijuana user and have been using on a regular basis. And that's because safety-sensitive positions, it goes with the name, are obviously different than somebody who's not performing anything that requires duties that could cause harm to them or others. So those safety-sensitive exceptions have been included in many of the laws enacted by states, and we do anticipate that if there's federal legislation on the issue, it would likely also include such an exception.
And that safety-sensitive distinction is also important for employers who do business or have operations in New Jersey. Under New Jersey law, when I'm looking at random drug testing, I can randomly test people who occupy a safety-sensitive position, but it is unlawful, it's a breach of the employee's privacy rights to subject them to random drug testing in the state of New Jersey if they do not occupy a safety sensitive position. So that safety sensitive distinction can have important consequences in other contexts broader than just marijuana.
Thanks, John. Agreed. And so the federal legislation on that issue could impact how employers nationwide conduct their drug screenings. With respect to, and John, would you mind moving just to the next slide?
Of course.
Thank you. So with respect to pre-employment drug screening, which John touched upon, a key issue is where marijuana has been legalized from a recreational standpoint, the question becomes whether or not employers should drug test their employees for that specific substance at all, and if so, how they should approach a positive result. And of course, again, with safety sensitive positions, there's an exception there in the states even that have legalized marijuana, to say that an employee, even if it's recreational, can't be under the influence, obviously, when they're performing very, work that's potentially dangerous to them or others. And there would need to be an assessment done by an employer as to whether or not it's worth the time and effort to drug test people if marijuana is legal outside of those safety sensitive positions. Of course, if there's an accident or if something happens in the workplace that results in harm to people, then employers can still do drug testing to see if somebody was under the influence. But in terms of pre-employment drug testing, the legalization and making recreational of marijuana in states is certainly going to raise questions as to how stringent employers want to be when they do and if they do conduct those drug tests. With respect to Pennsylvania Act 75, this is another important issue, and this law took effect in October of 2020. And Pennsylvania has essentially said under this law that employees who are working in the construction industry must be subject to the federal E-Verify protocols when they're hired. And an important caveat to this is it's not just employees, but the way that the law is written, it also applies to independent contractors, or as you can see on the slide, 1099 workers, we call them. And so people that are coming to work for employers in the Pennsylvania construction industry, they need to be going through the E-Verify process from October 7, 2020 of this year moving forward. And that's an issue that employers should pay mind to, including when they're hiring subcontractors to do work on their projects. For instance, if you're a general contractor, you have a subcontractor who's bringing people on the job to work. The law also would apply, and you would need to make sure that your subcontractor is putting people through the E-Verify process as well.
Well, Mark, thank you very much. I believe, and I have a couple of questions here. People are asking, where can I get these slides? So I'm glad that people are interested in looking at them and sharing them. If they will be distributed to everyone by email after this presentation, so you should all get a copy of the slide deck. We regularly post, and we plan to post a blog article on our firm's blog talking about a lot of the subject matter that we covered today, and we're tracking all of these and many more issues. We tried to squeeze in as much information as we could in this 1 hour, I guess, lunch hour time. I hope that everyone found the information useful. You can see my contact information, Mark's information, and if you have follow-up questions about these issues or any other labor and employment issues, please feel free to reach out to us. Thank you for attending. Thanks, Marc, for co-presenting with me. This was fun today.
Thank you, John, and thanks, everyone.
Okay, take care. Bye-bye.